Begin with our 130 matters, please.
23andMe Holding Co. et al.
Appearances in the courtroom.
Good afternoon, Your Honor. Tom Risky and Nathan Wallace, Carmody McDonald as co-counsel for the debtors.
Good afternoon, Your Honor. Christopher Hopkins, Paul Weiss, Rifkin, Wharton, Garrison as co-counsel to the debtors. I'm here with my colleagues Max Siegel and Jeffrey Rucker.
Very good.
Miranda Swift from Stinson LLP as proposed co-counsel to the committee.
Afternoon.
Good afternoon, Your Honor. Jason Adams, Kelly Dryan Warren, proposed counsel to the Official Committee of Unsecured Creditors. With me in the courtroom today is Megan McLaughlin, and on the WebEx today is Eric Wilson. We also have Andrew Scruton and Matthew Diaz from FTI Consulting, proposed counsel for the Official Committee of Unsecured Creditors, also on the WebEx, to the extent Your Honor has any questions with respect to retention applications.
Very good. Thank you.
Good afternoon, Your Honor. Josh Watts for JMB.
Good afternoon.
Not really.
Good afternoon, Your Honor. David Unsuff, law firm of Brian Cave, Leighton Paster, on behalf of TTAM Research Institute and Wachitsky ABC 2.0 LLC, and Wachitsky Revocable Trust, and the Ann Wachitsky Foundation.
Good afternoon.
Joe Schlotzhauer on behalf of the U.S. Trustee. Good afternoon.
Good afternoon, Mr. Schlotzauer.
Good afternoon, Your Honor. Michael Castle, Wachtell Lipton, Rosen & Katz for Regeneron Pharmaceuticals, Inc. as the successful bidder. I'm here with Ben Struby of Lathrop GPM.
I'm sorry, the last part?
I'm here with Ben Struby of Lathrop GPM.
Got it. Castle, sorry, my pens, as they tend to do, are all out of ink at the same time.
Yes, Michael
Yes,
Castle.
I got it. Thank you. Castle, thank you. Thank you, Mr. Castle.
Good afternoon, Your Honor. Joshua Jones, the United States of America.
Good afternoon. Any other appearances in the courtroom? All right, appearances on the WebEx.
Good afternoon, Your Honor. Camber Jones for KROC Tech LLC, and with me on the WebEx today is Mike Greger.
Good afternoon.
Good afternoon, Your Honor. It's Robert Hirsch, Norton Rose Fulbright. My something's wrong with my camera at the moment. I have to fix it in a second, but yeah, appearing for JMB Capital with Dick Lender.
Very good.
Good afternoon, Your Honor. My name is Kevin Barnes. I'm a Class A shareholder.
Welcome back, Mr. Barnes.
Good afternoon, Your Honor. Charles Vecito, Class A shareholder.
Welcome back, Mr. Vecito.
Good afternoon, Your Honor. This is Abigail Ryan with the National Association of Attorneys General, representing the 9 client states to which Oklahoma and South Dakota are joining. So we're a little larger now.
So those are your new clients, Oklahoma and South Dakota?
Yes, Your Honor. I'm going to update and add South Dakota this afternoon.
Okay, very good. Thank you. Good afternoon.
Thank you.
Anyone else?
Good afternoon, Your Honor. I'm Sage Nemetalahi. I'm counsel to the class action plaintiffs in Canada. It's a privilege to be here. Thank you.
Thank you, sir. Anyone else?
Good afternoon, Your Honor. This is Andy Goldman from Wilmer Hale in New York. We are proposed counsel to Neil Richards, the Consumer Privacy Ombudsman.
Very good.
Good afternoon, Your Honor. This is Dalila Jordan with the state of Minnesota, representing the people of Minnesota.
And Ms. Jordan. All right, Mr. Risky.
Thank you, Your Honor. Tom Risky for the debtors. As Your Honor is aware, typically when we have these hearings, I ask Mr. Hopkins to give an update as to where the case stands and some of the coming attractions. If it's okay with the court, as the court knows, we've agreed to push a number of matters to tomorrow, and I think as part of those accommodations, we're agreeing to not really raise any of those issues today. Is that satisfactory to the court?
That seems like a good idea. We could get sidetracked if we all decide we need to argue today about what we're going to argue about tomorrow, so I think that's probably a good plan.
Thank you, Your Honor. So as Your Honor knows, we filed a proposed agenda. I noticed from the court docket, Your Honor already took off the motion to reject. As Your Honor knows, if we can take that matter up, we filed a stipulation, Ms. Jones and Mr. Greger on. It contemplates setting a rejection date, contemplation of their administrative expense claim and payment, the offsetting of the security deposit, and some additional language in there just clarifying the removal issues with respect to the waste. But the long and short is that issue has been resolved. The parties have negotiated in good faith. We believe the settlement is in the best interest of the estate. So we've submitted that to Your Honor. So I just wanted to touch on that since it was.
Have the committee and the DIP lender reviewed that as well? The order, the general terms of the settlement?
To be honest, given the time constraints yesterday, no. That's why we went ahead and filed it, just so the parties could see it. But I'm happy to talk with them after the hearing today and talk to them about any comments before.
Sure. If you give Mr. Spidle a report about where that stands with the key parties, and then we'll take a closer look, and if there are any disputes, we'll get them resolved, of course.
Perfect. Thank you, Your Honor. With that, would the court be okay if we took up some of the retention matters and then save the stay matters till the end?
I think that would make sense. Sure.
Perfect, Your Honor. Well, up next is the debtor's application to retain Deloitte. As Your Honor is aware, there was a separate OCP application for Deloitte with respect to some of their services, but the services contemplated by this are more in tune with actual retention and 330 review. We haven't received any formal objections. The U.S. trustee did have some informal questions right after we filed it. We walked through those with them, so I do not believe there are any informal or formal objections to the application, so we'd ask that it be granted as submitted, Your Honor.
Okay, a question for you, Mr. Risky. The indemnification provisions seemed a little broader than normal. In the proposed order, at least the last one I looked at, didn't have the usual 3 paragraphs that sort of bring that back to earth. Is that one of the comments you received from the U.S. trustee?
It actually was not, Your Honor, but I'm happy to, now that you've highlighted that issue, go back and see if that needs to be reined in. No party has said that that's a point they need to die on with respect to the indemnification. I think that might have been a pullover from another one before that got refined.
Sure. I think the way we handled the Molis order, paragraph 12, is standard and ought to be acceptable to everyone. So first let me find out if anybody else wishes to be heard on the Deloitte retention. Apparently not. All right. So I'll grant the application, but subject to the usual language, as in the Molis order, for example. And if that's an issue, let's reset it and we'll sort it out. But I suspect it won't be.
Perfect, Your Honor.
And if you'd submit an order, please.
Thank you. I believe the next retention applications are those of the committee, so I'd see the podium, Your Honor.
Very good.
Good afternoon, Your Honor. Megan McLaughlin, Kelly Dry and Warren, counsel to the committee. On May 5th, Stinson, Kelly Dry, and FTI all filed their retention applications at docket numbers 383, 384, and 385, respectively. On the same date, we filed a notice of hearing advising all parties of the May 27th objection deadline and of today's hearing. The applications were served on the master service list. The certificate of service was filed at docket number 397. The committee professionals did not receive any formal or informal objections to their applications. I understand that the orders have been submitted to your chambers already. We're happy to resubmit if needed, but we request entry of those orders.
Okay, let's take them one at a time just in case someone wants to be heard. The Stinson application, anybody wish to be heard on the Stinson application? Okay, apparently not. I've reviewed that. It appears to be in order, so I'll grant that application, and no need to resubmit. If there's an issue with the order that we have, we will be in touch. How about the Kelly Dry application? Anyone wish to be heard on the Kelly Dry application? All right, Ms. McLaughlin, the only question I had there is the associate who owns a couple of shares of stock. If that were a partner, I would say maybe the partner should donate it to charity. Since it's an associate, how about we implement a formal wall as you would with a lawyer who comes over from another firm or government service or something like that? I think that will take care. It's obviously a de minimis issue, and as you mentioned, the associate's not going to be working on the matter.
Correct.
So,
sure.
So with that change, I'll grant the application.
Okay.
And I'll ask you to resubmit an order so you can describe your formal walling procedure using the correct terminology, and we'll look for that.
Thank you, Your Honor.
All right, how about the FTI application 385? Anyone wish to be heard? Very good. All right, I reviewed that one as well. The indemnification protocols there do seem to be standard to me, so I don't think we need any further tweaking there. And I'll grant the FTI application, and we'll run with the order that you've submitted.
Thank you, Your Honor.
Thank you. Up next, we have Wilmer Hale.
Yes, good afternoon, Your Honor. Andy Goldman again from Wilmer Hale, and I'm joined in the virtual courtroom by my partner, Kirk Nara, in Washington, D.C. Your Honor, we filed our application to serve as counsel to Neil Richards, the Consumer Privacy Ombudsman, back on May 13th, cognizant of the stipulation and order which appointed Mr. Richards. We styled this as a 327 application, and obviously went through the standards that one would go through with respect to disclosure, parties in interest, conflicts check, and the like. We received no objection from anyone, formally or informally, on the application. My declaration is attached to the application, explaining the procedures that the firm went through in terms of clearing conflicts and confirming for this court that we are disinterested and hold no interest adverse. We did file a short supplement just to disclose that Ryan Dury, who is going to work with Mr. Richards and assist him in Mr. Richards' tasks, at one point, because he worked for Amazon, held some Amazon shares and is also a consumer himself. That declaration, that supplemental declaration, was filed on May 30th. Again, Your Honor, we've received no objections. I'm happy to walk the court through the application if Your Honor has any questions or concerns. But again, no objections were filed. Nobody has reached out to us asking us any questions with respect to our application.
All right, thank you, Mr. Goldman. The certificate of service shows that the application was served on May 29th. So aren't we a little tight on timing here?
I don't. Yeah, well.
Your Honor, Tom Risky for the debtors. I think there was some confusion by the parties with respect to this. We agreed to file it on behalf of them to move this process forward, but I think there was some miscommunication with Kroll on serving that immediately. I don't know if there's a workaround to have it go on negative notice for a little bit longer to satisfy any notice concerns the court may have. But I think that's why it was served last week formally. That was the reason for the delay.
Negative notice is a creative solution. I don't have in front of me the actual language of what went out. If it would tell someone to object by a certain time, I could probably get my head around negative notice. If not, it may
file.
You want to send a supplemental notice?
Yes.
Okay. Well, look, the CPO should have counsel, and why don't you do that? Why don't you send negative notice giving 14 days from whenever that is for anyone to object to the Wilmer Hale application, and failing receipt or filing of an objection, you can submit an order on that. I do want to also talk at the same time about Mr. Dury. I don't understand from the application who Mr. Dury is or whether he has any connection with Wilmer Hale. I'm not saying Mr. Dury shouldn't work for the CPO, but I didn't get the sense that he's a lawyer with Wilmer Hale, and so I wasn't sure.
Oh, no, Your Honor. Yeah, first of all, I apologize. This is, with respect to the notice question, Your Honor, this is the first that I am hearing of any of this with respect to any delay or Kroll service. We had thought that this was served on May 13th when it was filed with the court. For any confusion, I apologize. I'm as surprised by hearing this as anyone. Beyond that, though, Your Honor, with respect to that question, no, Mr. Dury is not a Wilmer Hale lawyer. He is somebody who Mr. Richards knows well. He's the director of AI initiatives at Washington University, St. Louis School of Law. And I believe, although Mr. Richards is on, if the court wants to ask him directly, but I believe that in Mr. Richards' preparation of his reports to the court and the work that he is going to do, he is going to utilize Mr. Dury's services as necessary. And it is for that reason that I wanted to make sure that there was supplemental disclosure, both of Mr. Dury, which we did disclose, and then of Mr. Dury's very, if you will, tenuous parties and interest contacts with respect to Amazon as a former in-house lawyer and small shareholder, etc. I don't know if that answers the court's question in full or not.
That's helpful. I think Mr. Dury probably needs his own application. I assume he's a lawyer. He's a professional person, and I think he ought to apply, or the CPO ought to apply on his behalf to retain him as a professional person. So, primarily, Mr. Goldman, because your declaration about Mr. Dury is probably missing a little foundation because he doesn't even work for you, so why don't we, subject to the negative notice issue, grant the Wilmer Hale application, but let's carve Mr. Dury out into his own application. I'm not anticipating there will be any problem with that, but I'll take up any objections as they are, and we'll deal with that, and it won't impair the timing of his retention or his ability to charge for his time, beginning from the outset of his engagement.
That's fine, Your Honor. One last housekeeping matter, Your Honor, and I'm happy to file a second supplemental application if Your Honor would like. We obviously ran our exhaustive conflicts check off the parties and interest list we were provided at the time the parties and interest list was circulated. Mr. Richards obviously wasn't on the list because he wasn't there at the inception of it. And so we did not disclose, and we've just learned, embarrassingly for me since I've been a partner at the firm for now 24 and a half years, that from 2002 to 2003, Mr. Richards was affiliated with the firm, I believe an associate in one of our offices. Obviously, his world and my world don't really intersect in any way until now. But I did want to disclose that to the court. Obviously, that he left the firm 22 years ago. But I did want to disclose that to the firm. If Your Honor wishes, I'm happy to file a second supplemental declaration unless the record can stand as such with respect to this declaration and my comments on the record.
That is life at a large law firm. So without leaking into tomorrow's subject matter, there is a supplemental declaration from Paul Weiss about the bidders. I don't believe we've seen supplemental declarations from the other professionals who are interacting with the bidders about any connections with the bidders. So Wilmer Hale may be due to file something of that nature anyway, Mr. Goldman, and if so, go ahead and put the one-liner in there about Professor Richards' affiliation with the firm in the past, and that'll take care of that. But we'll take this up again tomorrow as necessary, but I do think the other professionals who've been involved in the sale process ought to get supplemental declarations on file and seal them as appropriate based on the order from last week.
Understood, Your Honor.
Okay, so we'll look for an order following a negative notice period on Wilmer Hale, and we'll look for a separate application for Mr. Dury.
Thank you, Your Honor.
Thank you, Your Honor. I believe that brings us to the stay motion, and Mr. Siegel will be presenting it for the debtors.
Very good. Mr. Siegel, shall we start with the motion to expedite?
Happy to, Your Honor. We've sought to expedite this motion because there is an impending hearing in the Canadian class actions that are the subject of our substantive stay motion. That hearing is scheduled to occur on June 16th, and despite the debtors' best efforts in Canada, respondents have thus far refused to agree to an adjournment of that hearing, and thus, in order to avoid all of the prejudice and harm to the debtors that would come from further proceedings in the Canadian case, we request that the court expedite this matter.
All right, does anyone wish to be heard on the motion to expedite?
Your Honor, I'm Sage Namatullah on behalf of the Canadian plaintiffs. I just with note for the record that I do not necessarily agree with my friend's characterization of the events. but we have no objection to the motion to expedite. Thank you.
Okay, thank you. Anyone else? All right, I'll grant the motion to expedite. Let's proceed to the merits, Mr. Siegel.
Thank you, Your Honor. The present motion seeks an order confirming that the automatic stay applies to 2 Canadian putative class actions, including as to certain non-debtor defendants. These class actions arise from the October 2023 cybersecurity incident that this court has heard much about in the course of these Chapter 11 cases. In the alternative, the motion asks that the court extends the automatic stay, and it also seeks an injunction against continuation of the Canadian putative class actions during these Chapter 11 cases. A Canadian court has already granted recognition of these Chapter 11 cases and thus is prepared to give effect to any order that this court issues with respect to a stay of the class actions. First, I'd like to deal with some housekeeping evidentiary matters. As an initial matter, we'd like to admit the declaration of Mary Buttery in support of the motion at docket number 434. Ms. Buttery is counsel to the debtors and the individual defendants in the Canadian class actions, and her declaration describes the proceedings thus far in those cases. She's available on Zoom should the court have any questions for her, but we understand the respondents do not intend any cross-examination.
Okay. Any objection to receipt of the Buttery declaration in evidence?
No objection, Your Honor. Thank you.
Okay, I'll receive it. 434 is in evidence.
And just for clarification, Your Honor, we'd also move to admit the exhibits to that declaration, which are all public records of Canadian court proceedings, including the complaints in the 2 putative class actions, an anonymization order in those cases, and a proposed amended complaint. We would offer those into evidence as well.
All right, any objection?
No objection, Your Honor.
Okay, thank you. They're admitted.
Next, we'd move to admit exhibits A, B, and C to the Siegel Declaration filed at docket number 435. Those documents consist of certificates of incorporation for the debtors 23andMe Holding Co. and 23andMe Inc. And they're public records that have been filed with the Delaware Secretary of State. We would request that the court admit those as well.
You said A, B, and C, but not D?
D is a red line comparison of exhibits A and D to the Buttery Declaration, so we think it's better considered as an illustrative aid rather than an actual item to be admitted into evidence.
Okay, fair point. All right, any objection to the receipt of exhibits A, B, and C to the Siegel Declaration 435?
No objection, Your Honor.
Okay,
Thank you.
those will be admitted as well. Thank you.
On the substance, Your Honor, this motion concerns 2 Canadian class actions arising out of this cybersecurity incident of October 2023, which has been the subject of many proceedings in this court. Respondents filed the first class action in October 2023, bringing contractual, statutory, and tort claims solely against the debtors. The claims focus on what respondents allege were deficient data privacy and security practices at 23andMe. Then, nearly 1 year later, in September 2024, respondents sought to add additional defendants to the complaint against the debtors. Namely, these are certain officers, directors, and employees of 23andMe, as well as KPMG, who was then the debtor's auditor. Instead of obtaining leave to amend, though, respondents filed a duplicate class action. They again sued the debtors on largely identical claims to the first class action and based their claims entirely on the same conduct as before. The only difference is that they now tacked on these additional defendants, calling them at least 3 times throughout the complaint co-principals and or co-conspirators. That's in Exhibit C to the Buttery Declaration, paragraphs 6, 9, and 47. This second complaint does not bring a single claim against the non-debtor defendants that is not also alleged against the debtors. and doesn't differentiate between the debtors and non-debtors in any way in the non-debtor claims. There are some claims in the complaints that are just claims against the debtors, but there are no claims that are just against the non-debtor defendants. I'm glad to walk Your Honor through the causes of action in the complaint, if helpful.
I've reviewed it. Thank you. I appreciate that.
The face of the complaint thus in no way reveals any sort of claim against the non-debtor defendants that's not also a claim against the debtors. And the proposed amended complaint, which is Exhibit D to the Buttery Declaration, is even worse in this regard. It pleads 5 causes of action, and each one of those is against, quote, each of the defendants. Unlike the plaintiffs in the many other class actions arising from the cybersecurity incident, respondents here have, to date, refused to pursue their claims in these Chapter 11 cases or to utilize the procedures that have been extensively negotiated and discussed for resolving claims arising out of the cybersecurity incident. And while it appears that respondents agree that the automatic stay applies to their claims against the debtors, they're continuing what amounts to proxy litigation against the debtors by bringing claims against the debtors, former directors, officers, and employees, as well as KPMG. And that's because the claims asserted against the non-debtors are the same as the claims asserted against the debtors, are based entirely on the debtors' alleged wrongdoing in the cybersecurity incident, and would result in recovery from the debtors because of indemnification obligations that the debtors undisputedly have. In fact, the cases are already taxing estate resources because the debtors are required to indemnify the individual defendants, not just for any judgment, but also for their legal fees.
So, Mr. Siegel, the response mentions that insurance is defending the litigation, and I didn't see a rebuttal to that in your reply. So, is the estate coming out of pocket for defense costs right now, or is an insurance company handling that?
At the moment, the estate is out of pocket for those. There is insurance that is applicable with a retention that may be waived in the case of bankruptcy, but ultimately the estate, at the end of the day, stands liable based on its indemnification obligations.
So is there a denial of coverage or dispute about coverage, or is it just you haven't reached the retention level yet?
My understanding is the latter.
Okay, thank you.
Now, respondents have not been able to identify a single case where litigation has been allowed to proceed under the circumstances I just described. In fact, they don't cite a single U.S. case in their briefing. By contrast, other similarly situated plaintiffs who have asserted claims against the debtors and non-debtors in analogous circumstances have reasonably consented to stay their cases, including against the non-debtors. Your Honor's familiar, for example, with the Pixel litigation that is pending against...
Well, I know that it exists, but that's... I don't even know why it's called Pixel. So
if
you want to go into that, you're going to have to spoon feed me a little bit about the Pixel litigation.
It's a class action that's not based on the cybersecurity incident. It's based on certain tracking pixels, as they're termed, on a website operated by Lemonade. But as relevant today, one of the defendants in that case is a non-debtor, and shortly after a suggestion of bankruptcy was filed, the district court in the Northern District of California asked whether the stay applied to the non-debtor defendant, and plaintiffs in that case came to an agreement and a stipulation with the debtors that applied the automatic stay to the non-debtors. And that's available on the docket at ECF number 216. But respondents, the Canadian plaintiffs, have refused to agree to any sort of stay or stipulation with respect to the non-debtor defendants here, which plainly is an effort to evade this court's jurisdiction and the orderly resolution of data breach claims that the parties and the court have sought to establish in these cases. The court should grant the motion for three fundamental reasons. First, as noted, the claims against the non-debtor additional defendants in the Canadian proceedings are identical to the claims against the debtors and arise from the debtors' alleged misconduct in the cybersecurity incident. In essence, the complaint says the debtors did something wrong and certain additional defendants are liable because of it. This means that resolution of those claims based on the debtor's alleged wrongdoing without the debtor's participation would be highly prejudicial to the debtors. Second, the individual non-debtor defendants have an undisputed right to indemnification for claims against them, which means that at the end of the day, the debtors are the ones on the hook for any judgment in the Canadian class actions, as well as for legal fees. And courts routinely apply the automatic stay to non-debtors in such circumstances. Third, the continuation of the Canadian class actions, even as to the additional defendants, would disturb these Chapter 11 cases where the debtors are presently resolving their other liabilities stemming from the data breach incident. By contrast, applying the stay threatens no prejudice to respondents who would face at most a slight delay while these Chapter 11 cases are resolved. The only argument that respondents have presented to the contrary seems to be that there is some hidden distinct liability theory as to the non-debtor defendants, but that's simply contrary to the face of the complaint. As I've mentioned to Your Honor, every cause of action against the non-debtors is also a cause of action against the debtors. The complaint states that it, quote, arises out of two main allegations, which are that, quote, the 23andMe defendants did not introduce, implement, and or maintain proper data retention practices, and, quote, the 23andMe defendants did not introduce, implement, and or maintain proper data protection measures and or practices. That's at paragraph 8 of Exhibit C to the Buttery Declaration. So simply, the suggestion that there is some sort of distinct liability theory is contrary to the face of the complaint, which says the debtors did something wrong and the non-debtors are liable for it. At the end of the day, the claims against the non-debtors are the same claims as those against the debtors, are based on the same conduct as of the debtors, and ultimately seek the same source of recovery, which is the debtors. And for those reasons, unless the court has any questions, we would ask that the court grant the motion.
Okay, thank you. I do have a few questions for you. Personal jurisdiction. The Canadian plaintiffs, at least in their declaration, have made what I'm interpreting as a special appearance. They're not acknowledging that this court has personal jurisdiction over them. Tell me your thoughts on that.
There are a couple of answers to that, Your Honor. First, as you mentioned, this is kind of a throwaway statement in Mr. Karp's declaration, and there's no argument in the motion whatsoever that there's a lack of personal jurisdiction. Typically, a party entering a special appearance would be required to contest personal jurisdiction in their first filing, which did not happen in these motions, nor in the stipulation that respondents previously agreed to, signed, and filed before this court. We also attempted to resolve any jurisdictional issues by agreement to proceed by motion, and therefore via an in rem proceeding in this court as to the scope of the automatic stay, rather than any sort of in personam adversary proceeding against the respondents. And I'm happy to speak to the minimum contacts that respondents have with the United States, if that would be helpful. But as noted, the Canadian court has recognized these proceedings and stands ready to give effect to this court's determination as to the automatic stay. In other words, this court could make a finding about the scope of the stay, and a Canadian court can then tell the trial court in Canada the proceedings have been stayed.
So I see your point about that aspect of the motion being more or less in rem. But if I need to extend the automatic stay to reach the plaintiffs, aren't we in the world of in personam at that point? Don't I need personal jurisdiction over these two plaintiffs and or their counsel to extend the automatic stay to reach them?
First, our counsel has appeared pro hoc vice in this court at this stage, and determining the scope of the stay would be a matter within this court's core jurisdiction. As to whether any further relief would require in personam jurisdiction, I think it's helpful to take a look at exactly what respondents have done here.
I do think, let's talk about minimum context. Give me an overview of that, if you would, please.
Sure. As an initial matter, respondents purportedly chose to do business with a U.S. company by purportedly entering contracts with using the products of 23andMe, which is a U.S.-based entity, and thus they availed themselves of the privilege of doing business in the United States. In connection with that, they received saliva collection kits from a U.S. company, collected saliva, sent it back to the United States for it to be processed by a U.S. company at a laboratory in the United States, and ultimately returned to them in Canada. On top of that, the respondents have initiated a lawsuit in which they repeatedly allege that the debtors are U.S.-based entities, and thus they've also recently filed a proposed amended complaint in that lawsuit. And by doing so during this bankruptcy case, I'm happy to provide case law to this court out of the Eighth Circuit that says that filing a lawsuit against a U.S.-based debtor during the existence of a stay constitutes minimum contacts and brings the respondents within this court's personal jurisdiction.
I haven't seen I'm not familiar with that specific case law. I don't know if you have it handy or if you have access to it, want to supply it in rebuttal or something like that. I'd be curious to hear about that because in poking around, I've not found anything quite that specific.
Yes, I believe that is cited in the adversary complaints that we initially filed, but I'm happy to find that and present it on rebuttal.
But that'd be helpful. Thank you. I appreciate that. Okay.
But even short of that, we'd submit that doing business in the United States, as respondents did via their use of the 23andMe kits, is sufficient minimum contacts for purposes of this motion.
And so it seems to me you're talking about a very specific kind of specific jurisdiction, or very specific aspect of specific jurisdiction. I have personal jurisdiction over these plaintiffs as to the scope of this lawsuit, and we don't need to think about whether I would have personal jurisdiction to handle a breach of contract claim against them or something much further afield from the core of the bankruptcy case. Is that the nature of your personal jurisdiction theory?
I think with respect to our in rem theories, that's certainly the case. With respect to in personam jurisdiction, I think there are sufficient minimum contacts to exercise specific personal jurisdiction regarding respondents' dealings with 23andMe, which they state form the basis of the claims in this action. There are no Canadian class actions without the exact business transactions I just described. I don't think the court needs to go farther than that in determining the extent of jurisdiction.
Okay, that's helpful. Okay, well, we'll give you a chance, Mr. Nimitolati, after I run through some questions. Thank you. Irreparable injury. So if I grant an interpretation of the stay or a preliminary injunction that stays this litigation, how long does that preliminary injunction or that stay last?
We'd submit that it would be appropriate, at least through the continuation of these Chapter 11 cases, so that they can proceed uninterrupted by what's going on in Canada. And we think it would be appropriate during that time to attempt to work with respondents, as we already have, to help them engage in the exact claim resolution process that other class actions against the debtors are undergoing at this time.
So we're talking about the stay or an injunction extending the stay through confirmation of the plan?
Let me consult momentarily with my colleagues. So, Your Honor, to clarify, we seek the stay through the effective date of the plan.
The effective date. Okay, fair.
And just to note one further point on jurisdiction, we are asking this court to issue an order with respect to the scope of the stay, but that order, as I noted, will ultimately be recognized by a Canadian court and enforced by a Canadian court, which unquestionably has personal jurisdiction over respondents.
Okay, that's helpful. All right, so if the stay extends or is extended through the effective date of a plan, what is going to happen in the litigation in Canada that's irreparable injury if I don't do that?
First, there is a hearing, as I noted, scheduled for June 16th. And
I'm sorry to interrupt, but the plaintiff's declaration says that hearing is only on a motion to consolidate the two cases. Is that right?
Part of that motion includes the amendment of the complaint. The amendments you can see at Exhibit D to the Siegel Declaration, and among those is to enlarge the class so that it is no longer just individuals in Canada whose data was breached and now expands to all 23andMe customers in Canada. That sort of vast expansion of the potential liability of the debtors or the debtors by proxy through the non-debtors is a substantial irreparable threat to the estate. The debtors can't see the scope of their liability expanding as they're trying to complete a reorganization. There are also changes to the claims that are sought in the proposed consolidation, and there are the fees that the debtors would need to indemnify the individual defendants for as the June 16th hearing occurs. Now, past the June 16th hearing, assuming that the motion is granted, we expect there to be proceedings regarding motions that, according to respondents' own words, will determine the universe of claims against the debtors. In other words, there's the potential for liability against the debtors to accrue via those proceedings and not give the debtors the breathing spell to which they are entitled. And subsequently, there will be motions for class certification, which do involve factual affidavits as set forth in Ms. Buttery's declaration, and that sort of fact gathering, much like any discovery that might subsequently occur in these actions, would squarely implicate the debtors.
So the plaintiffs lay out a pretty extensive timeline in their declaration, starting in paragraph 37, and you haven't really addressed that with the reply, but is that timeline roughly accurate? I don't have all the details on my screen here, but class certification, we're talking about 2027 or 2028, if I remember correctly?
I don't want to stand here and speculate as to what will happen in terms of timeline. As you see, the timeline set forth in Mr. Karp's declaration makes a vast number of assumptions about whether there will be appeals from different orders, the timeline for those appeals. What I think that the timeline does speak to unquestionably, though, is that if respondents are correct, then there is effectively no prejudice to them from issuing a stay through these fast-moving Chapter 11 cases to give the debtors a breathing spell from what respondents say will take many years beyond the Chapter 11 cases.
Okay. The plaintiffs refer to Ms. Wojcicki as a former director. I thought in earlier proceedings there was a discussion that she was still on the board but not on the special committee. I'm sure there's a straightforward answer to that. Do you have it handy?
For the record, Christopher Hopkins,
Sure.
Always for the debtors, Your Honor. Ms. Wojcicki is currently still a member of the board of directors of the debtors. She is not a member of the special committee that's been delegated effectively the full authority of the board with respect to all restructuring-related matters.
Okay. I thought that's what I remember. Thank you for clarifying that. All right. Then how about KPMG? I haven't seen anything about indemnification of KPMG, and I do see in the complaint some daylight between the claims against KPMG and the claims against everybody else related to the fact that they're the auditor, and auditors do different things than officers and directors do. And there's some discussion of that in the complaint. But the more important issue is indemnification of KPMG. Are they indemnified, and where is that in the record?
They're not indemnified, Your Honor, but nonetheless, the proceedings against KPMG are all about what occurred in the cybersecurity incident, and what little there is in the complaints that is specific to KPMG are, for example, statements that KPMG puts in advertising materials on its website. They're fundamentally ancillary to what respondents describe as the main allegations in the complaint, which are deficiencies in the debtor's cybersecurity practices and data retention practices. And KPMG, like the others, is alleged to be a co-principal and or co-conspirator.
Okay, and are they covered by the same insurance that covers the debtors? Or they have their own insurance, or no insurance at all?
I'm not aware of their being covered by the insurance policy that covers the debtors. Happy to look into that to the extent the court would like.
Okay. All right, I have what's going to sound like an oddball question, but I'll explain. Are the debtors offering any security in support of a preliminary injunction to the extent this heads in the direction of preliminary injunction? And the reason I ask that is I think the bankruptcy lawyers know that the court can waive security for a debtor under Rule 7065, but H.R. 1, the One Big Beautiful Bill Act, moving through Congress, contains language that could be read to make a preliminary injunction unenforceable unless security has been provided. And it appears to apply to injunctions that are in existence before the bill is enacted into law. So that's a very long explanation for why I asked what I think is an odd question.
Understood, Your Honor. We don't believe that security would be appropriate in these circumstances, given the financial distress that the debtors find themselves in, and the fact that even as to the non-debtors, as I've spent a lot of time on, those claims are fundamentally claims against the debtors. With respect to the Big Beautiful Bill, I'm candidly not certain of its application to this proceeding.
It's not the sort of proceeding that Congress has in mind, I'm pretty sure, but the language is vague.
Understood. And that, too, is something we're glad to look into if it would be helpful to the court. But short of that, answer is that a security wouldn't be appropriate given the distress that the debtors find themselves in, and that the non-debtor claims are really debtor claims.
Okay. Thank you. That's helpful. That's all the questions I had for you, Mr. Sieg. Thank you very much.
Right.
Let's hear from the plaintiffs or the I've been calling them the plaintiffs, the respondents in this motion. Mr. Nimatolali, am I saying that correctly?
Yes, Your Honor, absolutely correctly.
Very good. Please proceed.
Thank you, Your Honor. So just wanted to touch base quickly on the issues around jurisdiction and I guess relatedly the injunction and security for cause. I apologize if our claim or our declaration was maybe a little bit not as clear as it could have been. The language that we included was in response to the adversary complaint. Obviously, 23andMe had filed against our clients. We were shocked to receive that with no notice to us, especially so given the very first day of the commencement of these proceedings. We were in direct contact with counsel, Canadian counsel to the debtors, and we had stated to them that we would comply with the scope of the stay. There was absolutely no reason to file an adversary complaint, and especially with no notice to us. And just to be clear, the adversary complaint includes incorrect statements regarding the fact and the connection with the United States and whatnot. So that language in the declaration really speaks to the context of we're coming from that adversary complaint, adversary proceeding situation into this more proper forum to address the scope of the state. But besides that, there is really no dispute that Your Honor has the authority to extend or determine the scope of the stay. And if you determine that the stay should be extended to any of the non-debtors, we, of course, comply. As my friend indicated, the Canadian court has now recognized these proceedings in Canada that happened on our consent. So if Your Honor grants a further order with respect to the stay, and that order will have to be recognized in Canada as well, so we will consent to that very obviously as well. That is also to say also I don't think there is any real reason to have a discussion around an injunction. We have been compliant, and we said we will continue to comply with the stay of the proceedings that it may be in place. And on that note, I think the issue regarding a security for cost would also be moved.
Okay, thank you. That's helpful. How about the merits?
Amazing. Your Honor, we have a declaration of Ellie Card that I would like to introduce into evidence. That is docket number 584. That obviously is our narrative regarding the events and proceedings in Canada. The difference is that I did not object to the declaration of Ms. Buttery being admitted to evidence, but with respect, I do believe that it's incomplete in some respects. A very clear example would be where Ms. Buttery says, well, if the action proceeds, we're going to get its certification, and then there's going to be discovery. Well, that is correct, but let us bear in mind that that's not going to happen until 2029. So Mr. Clark's declaration provides further detail from our perspective regarding the procedure in Canada. So we do not accede to the declaration of Ms. Buttery, and we rely on Mr. Clark's declaration with respect to the relevant events and occurrences in Canada. So I would respectfully ask or move to admit Mr. Clark's affidavit, including the exhibits A through F, into the evidence before the court.
All right. Is there any objection to receive the CARP declaration and exhibits?
No objection, Your Honor.
Okay. It'll be received. Thank you.
Your Honor, my friend said in the written submissions and again on his feed that we do not cite to a single U.S. authority in our response, and that is not fair. The law is undisputed. We do not have any debate on the law. Frankly, in Canada, I can tell you that the concepts are largely the same. And we do rely on the same authorities that my friend cites in their motion. And specifically, I wanted to take you to this case from the appellate court in the circuit, which is called Ritchie Capital Management. It's a 2011 judgment of the court, and it's cited in my friend's motion at paragraph 39. So I wanted to take you to some excerpts of that judgment. I'm not sure if you have a copy of it, or if it would be possible for you to have a copy of it, or I can just read out to you.
I don't have a copy, but I've looked at it within the last hour, if that's helpful.
I think, Your Honor, if you allow me, I would want to take you to some of the language from the appellate court, because I think it's germane to what my friend was even saying. So this decision has, Roman numerals 1 and 2, and under 2 it has a section A and section B, and section B is the one that I'm relying on. And I'm going to read. I want to be complete and faithful to the decision, but I'm going to skip over some of the words and rely on the ones that I want to emphasize, especially given that Your Honor also read it just recently. But if you want me to go and read the balance of the excerpt, just maybe let me know. But the portions under section B that I wanted to highlight would be as follows. Whatever the precise scope of this category of action, it is significantly broader and more amorphous than the group of actions affecting the assets of the receivership. The federal court supervising an equity receivership has inherent equitable authority to issue a variety of ancillary relief to protect the receivership, and true enough, the scope of that relief is not limited to parties before the court. We accept that 100%. Permissible ancillary relief includes issuance of orders imposing blanket state of litigation in order to give the receiver a chance to do the important job of marshaling and untangling company's assets without being forced into court by every investor or claimant. But the court's power to stave off suits by third parties turn on these suits' ability to deplete the rest of the receivership state. The court's equitable powers do not reach cases that pose no threat to the assets of the receivership. In this respect, equitable powers of the receivership court are similar to powers of the bankruptcy court to impose an automatic stay. The goal in both securities fraud receivership and liquidation bankruptcy is identical: the fair distribution of the liquidated assets. The bankruptcy court can stay actions against any party, even a non-debtor, whenever the objective of the action is to obtain possession or exercise control over the debtor's property, unless a case involves unusual circumstances. However, the bankruptcy court cannot halt litigation by non-debtors. Even, this is very important for my purpose, Your Honor, even if they are in a similar legal or factual nexus with the debtor. And next paragraph says, the unusual circumstances in which the bankruptcy court can stay cases against non-debtors are rare. So I would pause here. So our pitch is simply, Your Honor, that we already said from day one to our friends that we're going to comply with the sale proceedings with respect to debtors. We agree that debtors must preserve estate. My friend said that we have refused to bring the claim within the Chapter 11 proceeding. That is not fair and not accurate. We have been in significant discussion, and we are looking into creating a channel to bring the claim in this court. And just so you know, the court, Your Honor has already granted what I refer to as a claims process order or claims bar order within this proceeding. The debtors did not give us notice of that motion. We had asked to be included on the service list. We were not provided with notice. And lo and behold, one day they say, well, the order has been granted. Now we think there is a way for us to in accordance with your Honor's order, to bring that claim within the Chapter 11 proceeding, and we are putting a lot of efforts to do that. But suffice it to say, the debtors have already secured what they wish to secure: a stay of proceeding against the debtors, a preservation of the estate of the debtors, and channeling all the claims against the debtors within this Chapter 11 proceeding. That has all been achieved. And now there is no, in the words of the appellate court, there is no unusual circumstance, which we already know are rare, to warrant that the claims against the non-debtor or KPMG be stayed at this time. And my friend keeps saying that the claim against the debtors and the former directors and officers and KPMG are basically right out of the same conduct of 23andMe. That is just simply false. We plead specific misrepresentations, and that is the evidence before the court. And my friend is actually now even acknowledging in their reply, they acknowledge, well, yeah, there is a specific misrepresentation have been pleaded against these entities. However, my friend said that the misrepresentations do not form the basis for any cause of action, which is also false, because we have a full reply, and that directs the court to the provisions of the claim that rely specifically on the specific misrepresentations we allege these non-debtors have made. So we, in our written submission, we identify for the court 2 issues, and under issue number 2, basically the question is whether this case is one of those unusual circumstances that it would be warranted to extend the stay of proceedings to non-debtors, and the answer is absolutely no. If we look at the facts, the claims are distinguishable. They're, in the words of the appellate court, they do arise from the same legal and factual nexus, but that is insufficient to grant a stay with respect to non-debtors. The claims against them is different. They are not going to be liable for the conduct of 23andMe. They are going to be liable for their own conduct, if they are to be found liable sometime down the road. That's point number 1. The claims are not identical. Secondly, there is no rational connection between the stay of proceedings and the restructuring efforts of 23andMe. KPMG is an entirely independent party, third party. They're doing their own thing. They have separate representation. They're not even involved in any role or capacity here. The former directors of the company resigned en masse in September of last year in an unprecedented situation. We went back in memory. We cannot recall any situation where all the independent directors of the company, 7 of them, resigned en masse. Just one time they said, we don't want to have anything to do with this company anymore. That was their wish, to not have anything to do with this company or the restructuring events anymore. So there is no rational connection. Thirdly, we say there is absolutely no adverse impact on the state. Absolutely zero. The defense is being funded by insurance. KPMG has their own resources. They're not on the insurance policies that we have seen. There are 2 sets of insurance policies that we have to understand. I have never seen any situation where the either would be on the same set of policies as the directors and officers or the company. They're not on the same policy. They have their own resources. They don't even have indemnification rights, whatever. As for DNOs, my friend says, okay, they have an indemnification right against the debtors. Correct. But a stay of the DNO claim is not going to dispose or resolve that indemnification right. presumably they already have, or they will have to file the indemnification right within the Chapter 11 proceeding. To state the claim against the directors and officers is not going to resolve that claim. What would resolve the claim would be to allow that their objections on pleadings or jurisdictional objections be heard. Maybe they're right. Maybe the Canadian court would agree with them to strike the claim on pleading against them, or find that the court doesn't have jurisdiction over them. That would be the end of any indemnification right they have asserted, or they will be asserted against 23andMe. To stay the claim against them is not going to address or resolve that claim. So that is for that reason that, we say the universe of the claim. My friend says that should, or argues that should somehow work against us. No, to the contrary. I just explained to Your Honor that the indemnification claim already exists because the directors and officers have already been sued. So how are we going to deal with it? Either it has to be addressed in the Chapter 11 proceedings, or if the directors and officers are correct that the claim should be struck against them, or the claim against them should be struck, that would be the end of the end of the debate. That's given a big chunk of the claim off the shoulder of the state. And I would pause here to say, this, at least as far as my experience goes, this is a peculiar insolvency proceeding because, as far as I know, there are no secured lenders. This is really an insolvency proceeding in pith and substance, and in large part to deal with these cyber claims. So anything that we can do to address this claim, and there is no cost for the state, it's the pleading motion. It's going to be funded by insurance. Anything that we can do to one way or another resolve that any of the claims of the creditors that arise from the cyber claim, I would submit to you, Your Honor, that should be welcomed by the court, because it's going to be streamlining the process, and it's going to determine what claims are going to stay and what claims are not going to stay. I misspoke. Are going to remain? What claims are going to remain as against a state, or what claims are going to be struck, and that's going to be the end of the debate. And lastly, we say, my friend said, there is no prejudice. It says, a slight delay. I don't know. My friend is really not committing to any timeline for Chapter 11, and you ask him, for how long this injunction should remain in effect. My friend is really not committing to a timeline. If it is a matter of these fast evolving and unwrapping proceedings in a matter of by fall we're going to be done before the Canadian court is going to even hear these preliminary objections on the pleading and jurisprudence, the Chapter 11 is going to be done, or substantially done. But on the other hand, we have the interest of, again, the debtors would not tell us, but about 700,000 Canadians in this privacy class action, and I have it before you that in Canada these are serious rights. And Canadian courts have very strong interest in them. They treat these rights as quasi-constitutional rights of Canadians and have very strong interest in educating them. And we often say, really, this, as plaintiffs' counsel, I deal all the time with, at least, I'm not saying it in a disparaging way, but defendants would like delays. They want to take their time. I deal with these delays very, very often, and there's a saying that says justice denied is justice delayed is justice denied. So we're in the same situation. We have the claim of this significant population in Canada. It has no connection with the debtor. It has no cost for the debtor, at least at these preliminary stages. And my friend is not committing to any timeline. Wants to basically get an order that stays the claim, sine die until we know when, who knows when. But on the other hand, we have a significant population of Canada whose quasi-constitutional rights are at stake. So in summary, and subject to any questions, Your Honor, the appellate court says we do not stay the claim against non-debtors even if they arise out of the same legal or factual nexus. We've got to have rare, exceptional circumstances and an imminent harm to the state resulting from the proceeding. And in my respectful submission, Your Honor, this is not a case of an exceptional circumstance. The debtors have already gotten everything that they would have wanted to accomplish. We have been cooperative since very, very first day with them, and we have complied with the stay. And the preliminary issues that are now before the Canadian court does not adversely at all, not in the slightest, affect the state in any way. But if there is any likelihood, as the DNOs are saying, that the claim should be struck on the pleading or for want of jurisdiction, I would submit to you, Your Honor, that let's determine that sooner or later, because that in fact benefits the state, and that in fact would advance the objectives of these Chapter 11 proceedings. Subject to any questions, those would be my submissions.
Thank you. So do you agree with Mr. Siegel on the scope of the June 16th hearing?
No, Your Honor. The evidence, Mr. Siegel is not qualified to provide any opinions on Canadian law. The evidence that is before the court is the evidence of Ms. Bottery, and Ms. Bottery has a brief description as to what this motion is seeking to accomplish. They do say that we are seeking to add defendants. That is not entirely accurate, because we are not adding any defendant who is not already named. The defendants are already there. We are just bringing the two claims in the same umbrella. And just so you know, because my friend did mention something, and Ms. Bottery had made some comments about the manner of the filing of the second claim. We do note in our declaration that Ms. Bottery raised the same objections with Justice Douglas. Justice Douglas was not very impressed, really. She said, that those characterizations were not correct. But if Ms. Bottery wanted to bring a motion, she could do that, which is yet to be brought. But in any case, this is how the events unfolded. The discussion around the claims with respect to the further defendants had been ongoing for some time. And again, we were dealing with a delay issue that we wanted to add the further directors without, of course, any prejudice that defense may have to bring, motions to strike the claim or state the claim. It would be entirely without prejudice. Defense were dragging their feet, not committing to any timeline. They were looking for dates. We were around September. They were looking for dates in December for that kind of just simple motion to add some parties without prejudice. And what happened as we were having these conversations, the directors resigned en masse. So from our perspective, to protect the interests of our Canadian class, we had to take the steps to file the claim, because we know in the situation of insolvency, those claims could entirely perish. So we would be.
Okay, hold on a second, Ms. Namathwai. I'm asking a much more granular question. What motions are being heard on June 16th?
It's a consolidation motion. So there are two existing applications to bring them together. Exactly, a joinder, if you wish, a joinder.
Okay, and are you seeking to broaden the class, as Mr. Siegel mentioned, from those who are known to be impacted by the data breach to all Canadians?
That is an excellent question, Your Honor. We are seeking to broaden the class. I say a couple things. That is a proposed class. That's not a certified class. So it has no bearing, no nothing with respect to 23andMe, and especially so that 23andMe is already subject to a claim process order of this court. So there's not going to be any claims against 23andMe at all going in Canada. So, and on the other hand, right now 23andMe has sent notification to all the customers. I think someone mentioned at some point 18 million customers, that any customer can submit a claim within Chapter 11 proceedings. So 23andMe has already invited any customer who might have a claim to submit a claim. The expansion of the definition of a proposed class, which is without prejudice, to a motion to strike, a motion to to stay for want of jurisdiction. And eventually, a certification motion has absolutely no bearing at this point in time.
Okay,
it's a proposed definition on paper that can happen as a matter of, the law in Canada. Someone can just propose a new definition at the time of the hearing of certification application. It really has no bearing other than the court will consider whether or not at certification, time of certification, whether or not that's going to be correct or should be certified. It's a matter of merely definition.
Okay. Let me see if I can summarize part of your argument accurately, Mr. Nimetulai. I think you were saying that litigation in Canada would benefit the debtors and their estates and the other parties in interest because your litigation would clarify issues, maybe in the debtor's favor, maybe in favor of the Canadian claimants, by determining whether certain parties are liable, whether the liability is coextensive with other parties, whether there's a valid claim under Canadian law at all, I suppose. Is that the point you're making, that you're helping the debtors crystallize what's going on in this case?
So, Your Honor, just to be clear, we have like 5 different arguments, and this is one of them, and almost, but not entirely. Why? What I'm saying is that the outcome of the Canadian case would only benefit the debtors and the Chapter 11 proceedings. Because what? Because the claim, and that corresponds with the indemnification claim that the DNOs have. And KPMG doesn't have any indemnification rights, so we're not talking about KPMG right now. We're talking only about DNOs. So what I'm saying is that the claim against DNOs is already there. A stay is not going to make it suddenly go away. If the Canadian proceeding proceeds, and if the DNO succeeds on striking the claim on pleadings or for want of jurisdiction, that can only benefit the state. Even if the Canadian court agrees with us, that still benefits the state, bearing in mind that then now the state knows that there is this valid indemnity, or on face, a claim that would not be struck, indemnification claim that would not be struck for the benefit of the DNOs. So when time comes to figure out how any proceeds should be distributed and how should all of the claims be discharged, etc., that is also going to benefit the state. However, I would go one step farther to just say, what a non-issue this indemnification right is, because we all know that at the end of the day, all these claims are going to be bundled together and they're going to be largely discharged. So my friend on his feet tells, at the end of the day, if there's judgment in favor of the DNOs like 5 years down the road in Canada, it's 23andMe that has to provide for indemnification. No. All the insolvency matters that I've dealt with, when there was a plan that was successful, it all discharged all the claims. This is only an academic debate that never comes into reality, never bears any air of reality. It's just, for people to say we have an indemnification right, but that is realistically against an insolvent company, it will never be realized. So it's all I'm saying that if at all, if anything, this Canadian proceeding would only benefit the state and these Chapter 11 proceedings, if at all. Not only that it does not harm the state in any conceivable way, not in the slightest. If anything, it would help the debtors and these proceedings before Your Honor.
Okay. Mr. Nimetulai, what's the prejudice to your clients if there's a stay of their litigation against all the defendants through the effective date of a plan, and let's say it's 6 months from now? What's the prejudice to your client if you're looking at a 5 or 6 year litigation timeline?
Well, firstly, that's a very good question. Firstly, there is no commitment that there's going to be like if my friend that said that the stay is going to be imposed only for 6 months, then I would have no issue with it, bearing in mind that realistically those applications that the DNOs and KPMG have indicated they would be bringing cannot be brought until probably December. The timelines are just like that. So if this proceeding, if my friend was going to commit to a conclusion or stay only for 6 months, I would have no issue with any of that. You reminded me, Your Honor, that I think my friend suggested that we have not been amenable to any sort of resolution, and if my friend said that, that is absolutely not correct. We have canvassed many various scenarios to come to a consensual arrangement, and none of them has worked. And I would just say for my friend to suggest that we have basically been being very difficult and not amenable to any resolution, that would not be accurate or fair. In any case, what I'm saying is that the timelines that we are looking at, realistically, these applications are going to have to be brought in December. So if there's going to be a stay only for 6 months, again, I'm not aware of any reason for that. But if Your Honor would be inclined to impose a stay for 6 months only, that would be perfectly fine with us. But an indeterminate stay, especially bearing in the other considerations where we say there is no unity of the claims, there is no identity of interest, there is no adverse impact, and so on and so forth. Well, any stay, especially an indeterminate stay, is totally unwarranted. And again, I direct you, Your Honor, to the language in the Ricci case that I took you to. We must treat a stay to non-debtors as a rare event to be granted only in exceptional circumstances, none of which exists here. And we do feel very strongly about these claims in Canada. You have it in the record before me. The Privacy Commission of Canada is conducting an investigation, and the Supreme Court of Canada has said that these claims are quasi-constitutional. They're important to us because they define our values as a democratic society. We have a very strong interest in educating them to set the standard that applies to all Canadians. This is like would not be the best analogy, but just to get a sense of where my head is. It's like in a criminal proceeding. You want the accused to have the fair trial with no delay. We're not the exact same situation, but the rights at the issue are quasi-constitutional rights of Canadians. If again there was any circumstance, we've done many of these cases. We could see if there isn't any adverse impact on the state, if there was anything really of substance, we would not be here. We would be agreeing to stay. We know how this should be done. But in this particular case, there's absolutely no reason whatsoever that would justify a stay. And again, I'm repeating myself, but I direct you to the language from the appellate court that there is no exceptional circumstance in this case to warrant a stay with respect to DNOs or KPMG.
All right, thank you. Appreciate it. The committee or any other party interest like to weigh in before we go to rebuttal?
Thank you, Your Honor. Again, for the record, Jason Adams, Kelly, Dry, and Warren, I think now officially counsel to the
correct.
of Unsecured Creditors.
Correct.
Thank you for that, Your Honor. Going to be brief because I always try to go with the mantra of not saying too much to put myself in danger here, because I think that the briefing and the arguments today were exceptional, and I think the debtors have laid out the case for why extension of the stay is appropriate here, and we do support it, Your Honor. I don't want to go through all the legal issues again. They've been discussed exhaustingly here. I'll talk about maybe one or two things, which is harm. Your Honor, you've asked questions about harm today. What's the harm to the estate? What's the harm to the plaintiffs here? I think the harm to the estate is very clear, and I think it was explained, but I'll highlight maybe a few points. Your Honor, number one, the desire for centralized reconciliation of claims and a centralized process for claims here. That's the purpose, one of the core purposes of the bankruptcy case that we're running here. Ultimately, hopefully, once we get through a sale process, which we'll talk about tomorrow, a plan. And that'll be addressed in terms of how we ultimately bring claims in. You've already dealt with that with the bar date. Reconciliation of claims that will either be dealt with down the road during this Chapter 11 bankruptcy or potentially after the bankruptcy process by another party or entity. To have peripheral litigation going on where we're not dealing with the centralized claims process here creates not only confusion, it creates cost and expense, and it causes distraction. There are a lot of litigations, as Your Honor knows. It was the opening comment from Debtors Counsel today. This is not isolated to a Canadian litigation. We have multiple litigations. We have arbitrations going on. We have state court litigations going on, all with respect to the same incident here. All of those parties in the U.S. have said, yes, we're going to come to this court. We're going to resolve our claims here. We're going to file proofs of claims, whether they're consolidated claims, whether they're going to be class claims. We obviously have briefing on that from one set of claimants already. So to say all of those claimants need to stay, come to this court and file claims, but another litigation can proceed, doesn't necessarily jive with an efficient way of reconciling claims. And it is going to force the debtors to take action in Canada. The debtors cannot sit idly by where claims against so-called non-debtors, and they are non-debtors, Your Honor, but it is the underlying issues of whether or not there was some error, mistake, problem by the debtors in terms of the data breach. That's the core of the questions that are going to be addressed in the Canadian proceedings. Whether you just say, well, we're just talking about the representations of the D's and O's or what KPMG did, it gets back to the core of what did the debtors do. And it's going to force the debtors to participate in that process. And that means cost, that means expense, that means their time. And we have a lot going on in this bankruptcy case right now, as Your Honor knows. Some of those issues we'll deal with tomorrow. Some of those we'll deal with them in the coming weeks. So any distraction from the debtors in terms of achieving the goals of this bankruptcy, which is maximizing value and coming up with an exit strategy, that's a harm to the estate. We heard about indemnification rights. We've talked about insurance rights here. Obviously, if the debtors are forced and required to indemnify, then any costs that are being incurred up there right now is a cost to the estate. And that's not something that we should be dealing with today. We can deal with those issues in the future. And if there's insurance covering this, then that's depleting a potential resource and asset for all stakeholders in this Chapter 11 bankruptcy. We don't want to see those depleted. So from the creditor's perspective, there's significant harm here, whereas a stay, not dismissal of the Canadian proceedings, not eliminating it, a stay of those proceedings and extending that to the non-debtors is minimal harm to the plaintiffs in this case. So those are my points on the harm, Your Honor. With respect to the June 16th hearing that would be coming up, Your Honor, I would reiterate, and I suspect counsel will address this as well, if there's a potential for expansion of the class happening at the June 16th hearing, then that's a significant impact on the debtors. It can't be that we're only expanding the class with respect to the non-debtors and KPMG. It means we're...
Well, it's somewhere in between, isn't it? It would expand the class, but the class is a long way from being certified. So it's expand the putative class. I don't know what you call that exactly. There is an impact, but it's not the death knell.
I don't disagree with Your Honor that it may not be the death knell, but it certainly is now expanding the pool of claimants that are involved in that litigation. Again, I think that's something that the debtors would be extremely interested in as it impacts them at a preliminary stage and would want to be involved in that. So again, we're dragging the debtors again back into the litigation in Canada, which would be problematic. And we've had some conversations around this June 16th hearing, and I guess the question is, and Your Honor may be addressing this eventually, is where are we stopping? Are we stopping at the June 16th hearing? Are we stopping at a July matter? You know, what's the next thing? And I don't think that's been really discussed today. But again, I think for judicial economy's sakes, for the estate's benefit, to minimize the harms here, a stay for now, which is, again, applicable to all of the other litigations that have to do with the data breach, makes the most sense. It's appropriate. It certainly satisfies the legal standard here. And so, Your Honor, we are in support of expansion of the stay in this proceeding.
All right, thank you. Anyone else wish to be heard before we go to the debtors for rebuttal? All right, Mr. Siegel.
Thank you, Your Honor. As an initial matter to something that my friend on the other side mentioned several times, if respondents are willing to agree to a consensual 6-month stay of the putative class actions as to all defendants, we are amenable to that. And
yeah, so if we were all here, this would be an opportunity for me to say you all should go out in the hall and talk about that. Would you like to have an opportunity to, through the miracle of telecommunications, talk about that with Mr. Nimatali without anyone being on a live mic? Is that helpful?
Is that a question for me, Your Honor?
Well, it's a general question. You're welcome to weigh in.
Well, we've always welcomed conversations around these topics, and I would not forfeit that opportunity now if my friend is inclined to call me.
Should we willing to take a short time?
Should we take a short recess?
Call?
Okay. Why don't we do that, and I'll let you all figure out how to not be on a hot mic. But it is that clock right? Yeah, it is 3:01. Should we take a 20-minute recess? What you tell me?
That's
20 minutes. All right. If you all are still talking, let Mr. Speidel know, and I will not emerge in the middle of your discussion. Ideally. Well, let's take a recess till 20 after 3.
Thank you.
Your Honor, we are back on the record.
Thank you. Please be seated, everyone. All right. Where do things stand, Mr. Siegel, Mr. Risky? Who's got the mic?
Yes, Your Honor. We conferred with Mr. Nimatali during the recess, and we're pleased to report that we appear to have an agreement. Under that agreement, the parties will mutually agree on a stay of the Canadian proceedings until the earlier of December 3rd, 2025, and the effective date of a plan. The debtors reserve their rights to seek an extension of the stay, and Canadian respondents reserve their rights to oppose such an extension. Neither party will use the fact of this stipulation to argue that the stay should or should not be extended. And the parties shall cooperate on adjourning existing hearing dates in the Canadian proceedings for a date on or after December 3rd. And at a case management conference that we were advised is scheduled to be held on June 6th, the Canadian plaintiffs will advise the court that they intend to seek an adjournment of the hearing on the consolidation motion until the week of December 15th, or the Canadian court's convenience. We are glad to memorialize this in a written stipulation and submit that to the court.
Sounds great. Mr. Nimatali, is that consistent with your understanding?
Thank you very much, Your Honor. It's absolutely a privilege, and thank you to our friends. This is an agreement. We have agreement on the terms that my friend just advised the court. Thank you.
Very good. All right. Well, thank you. I appreciate the parties getting their heads together on that, and sounds like a mutually beneficial resolution. Very good. Anything further for today, then?
Nothing from the debtors, Your Honor. Thank you.
Committee, no? Okay. Very good. All right. We have matters scheduled for 1:30 tomorrow, and so we'll see you all then. Court will be adjourned.
Thank you, Your Honor.
Thanks, everyone.